She's going to introduce a new exhibit. It's the tracker report that we have marked Exhibit P. Just beg leave to hand up the new Exhibit P. Her name is Miss Maria Elizabeth Pretorius.
Has the defense had an opportunity of studying that report?
Yes, indeed. It was given to them, I think, on Monday, my lord.
That's correct, Mr. Mbuzo.
That's correct, my lord. My lord, before the witness can be led by the state, I would like to request the basis for introducing this evidence before this court. And which kind of evidence is it supporting? Because in my true recollection, I don't remember any witness talking about the registration numbers of this vehicle. Moreover, my lord, this motor vehicle is alleged to have been driven by Longwe Twala. And why it is the prerogative of the state, of course, not to call him. But what are the intentions of the state to lead evidence that relates to Longwe Twala? The state has clearly stated that they are not going to call Longwe Twala. And this witness cannot prove, in terms of the location of the vehicle, we are not sure about the registration numbers of that motor vehicle.
Is that all?
Why Longwe Twala is not called? The state does not want to advance genuine reasons as to why they are not calling Longwe Twala, being the driver of that vehicle on that particular day. The basis for this objection is that in relation to the movement of this vehicle, it amounts to hearsay, and that the evidence that will be elicited by this lady, especially that deals with the registration numbers of the vehicle, we are not sure whether that vehicle was the one that Longwe was driving on that particular day.
I don't know.
I'm addressing the court so that I'll put it on record.
Fine, yeah.
So that the state can respond from my submissions.
Okay. Mr. Ramsipedi?
As the court pleases, my lord, in as much as the state is dominus litis, I cannot tell the state which evidence to lead. The state needs to be honest with the defense. Yesterday we were informed that this lady will not be coming anymore. And then we are resuming with Colonel Gininda. We're going to hear from Colonel Gininda whether he wants to testify during his writing of the exams or whether we stand down until he finalizes exams, then we come back. Now today, to our surprise, this lady is here again. I can honestly tell the court I've never consulted accused number 2 regarding this document for that reason, my lord. As the court pleases.
Mr. Mnishi?
That is the same position.
Same position.
When we were meticulously informed that we are unable to get hold by the state, we were informed by the state that they are unable to get hold of a person from the ABL company, therefore we proceeded with Mr. Gininda's evidence. That's what we are expecting to be happening today. Thank you.
Have you heard of the adage that Jesus Christ arose from the death after 3 days?
I'm a Muslim.
Yeah, fine, but
yes.
the Christians and the Muslims know that. I'm saying the Muslims don't know that there's a gentleman called Jesus Christ.
No,
Never mind that.
Jesus Christ, I don't know him.
You don't know? Okay, fine.
But I'm in the same position. I have
Yes.
not consulted with my client. I was under the impression that Brigadier Gininda is going to be coming. In fact, he gave us assurance yesterday that he was going to be here, so that we resume with his evidence.
Ms. Mshololo?
Same position, madam.
Same position. Mr. Beloyi, what's your answer to the...
Well, maybe to start with the submission of Mr. Ramusipili that the state indicated yesterday that the state was no longer going to call the witness anymore. That is not correct, my lord. We said we couldn't trace the witness yesterday, and that as a fallback position, we're going to call Brigadier Gininda. But we managed to trace that witness, and that is the reason why we're calling the witness now. Now, as regards the submissions of my colleague, Mr. Mgomezulu, firstly, there's no evidence regarding the registration number. Should that become necessary, my lord, we will lead evidence on that. But he has invited the state to address the court on why the states intend placing this evidence before court. And for that reason, my lord, we've prepared brief heads of argument that we want to advance. We'll just give a court a copy. But we foreshadow our heads by referring to.
As it is the I do not intend to stop what the state intends to do. But this is a horrible ambush. The state is preparing heads of argument on what? Who has requested the state to prepare heads of argument? Because once the state is preparing heads of argument, we will also be expected to submit our own heads of argument. We don't know what these heads of arguments are, whether they need our response or what. Procedure does not.
Yes, Mr. H.
That's not how the procedure is done.
My lord, Mr. Mgomezulu is inviting the state to address the court on the relevance of the evidence.
Right.
Now we're trying to do that, and now there's an objection. We submit that the defense cannot stop the state from advancing an argument. If they want more time to prepare the argument, they're at liberty to do so, my lord, but they can't stop the state from advancing its own argument.
Yes, Mr. Nisi, you say you can't stop the states. That's what Mr. Valori is saying. From advancing reasons why this witness is being called. Because Mr. Mgomezulu has elicited that information. And now the state says it is responding pursuant to that elicitation by Mr.
When was
Mgomezulu.
that raised, man? When was it raised?
No, but
that the state needs to explain the basis why this witness been called.
No, but you're not listening. The state says Mr. Mgomezulu
Yes.
says he wants the reasons why this witness must be called. Is that not so, sir?
Indeed, my lord.
And then you say these heads
Yes.
are intended to address that exigence. Wait.
Okay.
Are they intended to address Mr. Mgomezulu's exigence?
Indeed, in fact, if I can just correct Advocate Nisi, as early as yesterday,
Yeah.
Mr. Mgomezulu signaled his intention to object to the evidence,
Yeah.
and it was on that basis that we prepared the heads.
So you want a ruling on that, sir? Can you stop the state from calling any witness?
That's exactly what I'm saying, man.
No,
We cannot.
but I'm asking, can the defense stop the state as the dominus litis from calling any witness?
I'm addressing that, man. I'm responding to that.
Okay.
That is strike law, man.
What is strike law?
It is strike law that the state can read whatever evidence that they want to read, whether it is relevant, irrelevant,
Right.
necessary, unnecessary, whether evidence is there or not there. They can read whatever that they want to read, but there should be a basis for reading that evidence. It is very simple, madam. I mean, if
But Mr. Nisi, Mr. Valori says this is the basis. Sir, are you not saying that?
Yes, indeed.
I'm listening. He says this is the basis, and you are saying there must be a basis. Here is the basis according to Mr. Valori.
I'm not saying there must be a basis, man. I only had Mr. Mgomezulu today on record saying that the state should indicate the reason why they would want to lead this evidence, because the testimony of this evidence will be a continuation of the hearsay above hearsay.
Fine.
I heard him now, but the state already has prepared this of arguments.
Mr.
Why
Baloy,
are we
sorry.
supposed to respond
Mr.
to
Baloy
this?
says he was duly advised, or it was intimated to him by Mr. Mngomezelo yesterday that he's going to object to the recording of this witness. That's why he has typed and prepared these hits.
Unfortunately, I wasn't privy to that communication. but that maybe-
I heard that.
Maybe it's an issue.
Mr. Mngomezelo, I'm misquoting you. Yet you said, we are going to object to that evidence. Did I hear you correctly, Cecil?
My Lord, I've indicated that way.
Yes.
My Lord, there's one thing that puzzles me. It was just an informal discussion between myself and Mr. Baloy. We were made to prepare. We even listened to Brigadier Kininda speaking. We're preparing for this. If Mr. Baloy or Advocate Baloy was intending to serve us with these heads of argument, he could have done that, even electronically. It doesn't do that. It
So
can't-
you want time to peruse the hits?
we still have to respond from what he was responding on.
So how long do you need for these hits? There are how many pages? 5 paragraphs, 6 paragraphs.
30 minutes is fine. 30 minutes is fine.
30 minutes. Well, I'm sorry about this. Okay.
My Lord, if I can make a proposal that we go ahead, advance our argument, and if they need time to respond to that, my Lord, they can do so. And Mr. Mngomezeli himself, yesterday when we resumed, he put it on record. It was not a private discussion. He put it on record that he's going to object to the evidence of the person from Trekker. I'm surprised that he says it was a private discussion. It wasn't. It was on record.
Mr. Baloy says maybe he should lead the witness, and thereafter we adjourn, and if you want to, as you say, you want 30 minutes. Is that okay?
My Lord, I thought he was saying he was going to advance his reasons
Yeah.
for this
But
witness
he
to be
says,
called. Not for this.
as he says he's advancing the reasons. But
Yes.
he also says he should lead the witness first. Am I correct?
No, just advance the reasons,
The
my Lord,
reasons.
and if they want to
Oh,
respond,
I see. Fine. Okay.
yes.
Okay. I'm sorry about it.
There's a court, please, my Lord.
Yeah. Okay. Can we start then?
Yes, we are on page 1. We mentioned, my Lord, that Mr. Mngomezelo has indicated that he'll object to the evidence of this witness, and we then give background of the propositions that Mr. Mngomezelo put to the witness, and under introduction we quote the record. This record, my Lord, are the proceedings that occurred on the 28th of August 2024. He put the following proposition to Lieutenant Colonel Mangena, Mr. Mngomezelo. All right, let me put it, and my Lord, I must apologize, there are a lot of words in these heads that are just fresh from the printing press. We just prepared them shortly before we started this morning. Mr. Mngomezelo, all right, let me put this version to you. According to those witnesses that I do not want to disclose at this stage, 3 shots were fired. 1 shot is the one that caused injury to Zandi on her leg. The other shot is the one that Longwe Twala shot himself on the leg while they were struggling for the gun. The third one is the one that shot Senzo Meyiwa. Says, but I'm not mentioning, then on page 3, I'm not mentioning them according to the sequence of how they happened. I mean, all these 3 shots, they cause injury to Zandi, The one was stuck in the angle of Longwe Twala, and the other one is the one that shot Senzo dead. Then Mr. Mangena he says, he doesn't know of any injuries to Longwe. Then Mr. Ngomezulu. Longwe, after that incident, that wound became septic, and he went to a doctor, the late Dr. Mbatsani, who referred Longwe Twala to Dr. Modise at Rand Hospital, where a bullet was taken from Longwe's foot. Then we go straight to paragraph 2, my lord. We mentioned that these allegations are so serious as they go to the heart of what is at issue in this case, and they ought to be investigated. And my lord, if AVL or auto vehicle location records can assist the court in the determination of these issues, that it is in the interest of justice that this evidence be allowed. In paragraph 3, we mentioned that automatic vehicle location is a computer-based vehicle tracking system used to monitor the movement of vehicles. It helps to determine and transmit the geographic location of a vehicle in real time. And as we submitted when we dealt with the evidence of Mr. Declared, said it's eye in the sky. Mr. Ngomezulu says this is here evidence. It's not here, it's hearsay evidence. No, it's real evidence. It's digital evidence, and it qualifies as real evidence. In paragraph 3.1, we mentioned that the AVL records will therefore show the movement of the Polo, including whether it drove to any medical facility, in light of the proposition that was put to Colonel Mangena that Mr. Longwe Twala shot himself in the foot. And 3.2, in contrast to what Mr. Ngomezulu submitted, we make the point, my lord, that AVL records are independent, objective evidence, and as it were, a silent witness, and we draw parallel with cell phone records, my lord. They're just like cell phone records or bank records. One can surely not argue that cell phone records or bank records are hearsay evidence if there is a witness who comes and give testimony on those records. In paragraph 3.3, we briefly mentioned that a tracking device is installed in a particular vehicle which provides vehicle location information, and a witness from a tracking company, and the witness is now here, would come and testify that in this case she retrieved the information from the system and testify about the period to which it relates. In paragraph 3.4, we mentioned, my lord, that Mrs. Zandi Kumalo, Mr. Tumelo Madala, Mr. Mtokozisi Twala, and to a certain extent Mr. Kai Nashe, inter alia, testified about the presence of a red Polo on the premises on the evening of the incident, and that Mr. Longo Twala was the driver. This, in our submission, my lord, renders the evidence reliable and validates the information that the AVL records will provide. In paragraph 4, we deal briefly with relevance, that the starting point is that all relevant evidence is admissible. We refer to section 210 of the Criminal Procedure Act 51 of 1977, which provides as follows, and we quote, "No evidence as to any fact, matter, or thing shall be admissible which is irrelevant or immaterial and which cannot serve to prove or disprove any point or fact at issue in criminal proceedings. And we then quote the esteemed author de Croy, where he says the following: relevance of an item of evidence refers to its logical tendency to show or indicate the material fact for which evidence is offered. And the learned author says relevance is essentially a question of fact, and we refer to the commentary on the Criminal Procedure Act. It's pages 24 to 22b, 24 to 22 to 22. And we mentioned, my Lord, that at times the distinction is often drawn between facta probanda, that is now the facts in dispute, and facta probandum, that is the facts that are used to determine those facts that are in dispute. In this instance, my Lord, a proposition has been made that Mr. Longwe Twala shot himself in the process of shooting the deceased, and the AVL records would assist the court in determining whether that proposition that was put forward is likely to be true or not. Then interest of justice, we will not deal much with that, my Lord. We submit that it is in the interest of justice to allow this evidence to determine the movement of Longwe in light of the version that was put to Colonel Mangena. And we refer to the the local classicals of R versus Hepworth. We give the quotation there that the duty of the trial judge is not only to direct and control the proceedings according to the recognized rules of procedure, but to see that justice is done. And we also refer to this case of State versus Shea. The reference is given there. We just want to quote what was said there, that the applicant stressed that they place their reliance on the general right to a fair trial, which, as this court has held, extends beyond those specific rights enumerated in subsections 35(3)(a) to O of the Constitution. The right to a fair trial requires a substantive rather than a formal or textual approach. It is clear also that fairness is not a one-way street conferring an unlimited right on an accused to demand the most favorable possible treatment. A fair trial also requires fairness to the public as represented by the state. It has to instill confidence in the criminal justice system with the public, including those close to the accused, as well as those distressed by the audacity and horror of crime. We also refer to the multi-choice case, and we give the reference there. We just want to place on record the what the SCA held by the current JP of this division, but then the SCA judge, Judge Mlambo, he held as follows: our constitutional code has been vocal regarding the protection of the right to a fair trial. Indeed, any accused person who appears in a court of law facing any charge has the constitutionally guaranteed right to a fair trial, which includes the foundational values of dignity, freedom, and equality, which are central to a fair trial. And they then quoted the case of Zukuza. We give the quotation there, where in the court held that a fair trial is a comprehensive right and embraces a concept of substantive fairness, and that at the heart of the right to a fair criminal trial and what infuses its purpose is for justice to be done and also to be seen to be done. And finally, we refer to the case of State versus Lameni, Dal and others. We give the quotation there, where the then Constitutional Court Judge Krichler held as follows, that the phrase interest of justice is a useful term denoting in broad and evocative language a value judgment of what will be fair and just to all concerned. We therefore submit, my Lord, that the state should be allowed to examine this witness on the AVL.
Can interpret.
That's the consequences. Lapha-ke kukhona-ke okufakwe ummeli kuba uMngomezulu ethi yena ngeke athandisise ukuthi lo fakazi eze azoletha ubufakazi enkantolo. Base kufundwa-ke okwakukhulunyiwe ngomhla ka-28 August 2024, and lapho-ke ubaba uMngomezulu ekhuluma no-Colonel Mangena okwavela lapho ukuthi kwadutshulwa kathathu, khona inhlamvu yokuqala eyasha uZandi, enye-ke inhlamvu kuthiwa-ke uShlongwe thwala wazidubula yena wazilimaza ngesikhathi-ke belwela isibhamu. Eyesithathu inhlamvu kwathiwa yile eyadubula uSenzo Meyiwa, kodwa-ke kuthiwa-ke njengoba kubekiwe kokuthathu lokhu akubekwanga ngendlela okulandelana ngayo. Kuthiwa-ke uLongwe kwahamba waya kuDr. Mbatsane lapho wamdlulisela ukuthi bayomkhipha inhlamvu. Manje-ke lo bufakazi lobu busiza ukuthi-ke kwazi ukuthi imoto yahamba ngoba uma kungavela ukuthize nokuthi imoto yadlula yakodokotela kuzobonakala ukuthi ngempela le moto yayishayelwa ubani. Manje kuba uMngomezulu ukuthi lo bufakazi obulethwa la enkantolo abone ubufakazi obuqotho, ubufakazi nje abuzwa abantu kuthiwa hearsay evidence isilungu, and then umsheshisi yena uthi cha ubufakazi ngempela lo ngoba kuzokhombisa ukuthi imoto yahamba yaya endaweni la uthola unemtholampilo khona, futhi-ke uthi lokhu kuqhathanisa futhi nama-cellphone record. Manje-ke impikiswano-ke lapho ukuthi kuyalethwa indlobufakazi la enkantolo kusho ukuthi yebo akakhulume usisi lokho emlethela enkantolo, sokuzobeke nempikiswano ngalokho.
Yeah, the defense, do you need more time? If you want to prepare your own arguments on paper, all the better. Because I don't want anybody to say he never had an opportunity to respond to this document. So if you want us to adjourn until tomorrow, I don't have a problem. And then you prepare also a substantive argument.
Madam, speaking on behalf of Mr. Meyiwa, I'm ready to respond now from the bar.
Mr. Mngomezulu,
I'm ready to respond from the bar.
Mr. Msipiri,
I will also respond from the bar.
Mr. Ngumalo,
I will also respond from the bar. Thank you.
Ms. Mshorolo,
I have no submissions.
you have?
No submissions.
You must have. You can't be in the air. It's either you are in heaven or on the ground.
My Lord, if we were to look at the procedure, the way things are happening, the application has been brought by the state, then that will mean that the defense will also have to be given time to prepare their
That's it. I want to give you the time if you so want it. But your four colleagues here, they say they are ready. If you say you want extra time, it is your client's constitutional right to insist on that.
As the court visits, my Lord. If that can be allowed, I'll ask that opportunity, my Lord.
How long do you need? A day? A week?
I can prepare my heads tonight and submit them tomorrow.
Ma'am, where do you live? I'm sorry to ask you that. Don't give me the street and the address. Are you living in England or where? Oh, you're my neighbor here.
Yes,
Okay, are you available tomorrow?
yes, I am alone.
Yeah, you heard the argument.
I did.
Yeah, the defense has a right to respond because according to Mr. Mngomezulu, he says they are ambushed.
Yes,
Lavasne Ferrier.
I do understand the law.
Okay. Yeah, because of that existence, this court will adjourn until tomorrow.
My Lord, if the case is adjourned until tomorrow, my Lord, can I ask that I be given opportunity to consult on this document with accused number 5 so that he cannot be taken immediately?
Fine, no problem. Because normally number 5 goes to where he stays at about 4 o'clock. Is that not so?
Yes, my Lord.
Where's General Brigadier Ginin? Have you sorted out that thing amongst yourselves?
I have explained.
Amongst yourselves.
Indeed, I've explained that to my colleagues, and I think to afford him some privacy, my lord, if we can address this issue off record, off record, my lord, in light of the fact that the proceedings are carried live. It's an issue that we request that it be addressed in chambers.
You're excused, well. We'll see you tomorrow at 10 o'clock. Okay? Sorry about today. Sorry, Mr. Balui, you say the record of the, you call it what, an AVL machine?
Yes, that is exhibit that we have placed before.
Yeah, I'm saying you have given it to the councils, all of them.
Yes, on Monday.
All of them, okay, so fine. So you want us to address this issue in private? Why should it be private?
Well, I think someone's studies are, a private matter.
No, I don't like privacy because people talk a lot. They'll say we are doing this and this and this in private. Mr. Gininda, Brigadier Gininda, I think, can tell us what he thinks about, and then even the councillors can come in also.
Yes.
And if they think it's not necessary for him to be excused from his studies, that's it.
Well, I've communicated to my colleagues this morning what his preference and request is, my lord, because the court wanted to know whether...
Where is he? Let him come and say it here.
Okay.
I think it should be that way. Okay.
Okay.
Please, be around.
Yeah, he can be made of... I think if we adjourn for a few minutes,
fine.
He can be here. was whether in between his exams,
Yeah.
he can give testimony.
Yeah.
And initially, his stance was he'll put the interest of this case ahead of his studies.
Right, fine.
But upon reconsideration, and after we have traced this witness, he then indicated, my lord, that his choice would be that he first write his exams and then thereafter come and testify. And that is what I've told my colleagues this morning, my lord.
Are your colleagues agreeable to that suggestion or not?
Well, I told them so that they can ponder about the matter. They haven't really, I haven't really heard what their standpoint is.
No, let me tell you my experience. This is the first time it happens that that is happening through the court. I've sat in cases where you find that a person is accused and is still a university student or a scholar. And then he says he's going to be writing exams, like for instance today, up to the end of the week. And then the judge would, for uncompassionate reasons, would say, okay, fine. We'll postpone this case until you have written your exams. And in this case, also, this is uncompassionate reasons. I know there are people who come and say, hey, this constitution, aina Ubuntu. You know the principles of Ubuntu. The first judge to write about this was the late Chief Justice Langa. You've read those cases where he extols the principles of Ubuntu.
Yes.
Yeah, if you are black and you are humane and you subscribe to the principle of Ubuntu, there's a person who is supposed to write exams, and then your conscience, what does it tell you? Is it fair for him to give evidence today, write exams, give evidence, write exams, give evidence, write exams, and thereafter he's cross-examined? Fine, no problem. What does your sense of justice tell you, or compassionate, or humaneness? For me, but I'll go along with what you are saying should happen. If you say he must come and give evidence, fine.
Well, that's precisely the points that we discussed yesterday, my lord, that perhaps on compassionate, as
some compassionate reasons,
grounds, that consideration be given to allowing him to write, to sit for his exams and finish. And experience has taught us in our student days that it's difficult to divide your attention.
It's obvious.
When we're dealing with exams, but yeah.
So you say he's coming at 2?
Yes.
Okay, fine.
He might be here a bit earlier. But in the meantime, my lord, my colleagues...
How many days is he writing anyway? How many days?
We'll be consulting.
How many days is he writing?
As indicated yesterday, my lord, it's several days. I think it's about 6 days.
6 days.
But he indicated that some of the modules are what they call portfolios that require you to do research and then prepare. And he says it's only those modules, my lord, that require the portfolios, that require more time, that he will then request more time on. So he was going to then come back to us and indicate which ones are modules, which ones will require more time, on the basis that they are modules. And perhaps when he comes here, he will then give us.
Yeah, this court is compassionate. I waited for a witness for 1 year. 1 year. Mr. Potgieter, is it Mr. Peterson, for him to be consulted by the councils and for him to be present so that the cross-examination of that witness, Mangena, could begin. Because it's the right thing to do. So, with,
I also make submissions.
yeah,
Thank you. I'm not so sure what the state has told the court is exactly what transpired yesterday.
they haven't told me anything. They told me everything here. That's why I wasn't here when you spoke. Everything Mr. Baloyi tells me, I hear it in court, not in passages.
And that is the reason why I'm saying, my lord, I'm not so sure whether what transpired around Mr. Brigadier Ibuda's availability to come testify has been properly conveyed to the court. So, but nonetheless, let me take the opportunity to inform the court what actually transpired.
Okay, fine, yeah.
Apparently yesterday, when we had adjourned, and that is what I'm told by my colleague, I wasn't party to that. Mr. Kileda was here. Oh, not really here.
Wait, not really here.
I would appreciate the court to really give me a hearing in as much as it did when the state was.
No, but you say he was here, then you say he was not really here. I want to understand not really here.
What I'm saying is, as that conversation was happening, I was not part of that conversation. So what happened is, and my colleague will come and amplify that. It is only a ground. They called him and they put him on the speakerphone. They indicated to him, and there was a conversation around his availability to come testify. He indicated that he does not have a problem to come testify and be given an opportunity a day before he writes an examination to go and prepare. That was the arrangement yesterday. As I'm saying, my colleague, rather for the accused and the state to come and amplify that. So if all of a sudden,
Yeah, no.
all of a sudden today, hardly 18 hours, it comes, or there is information that comes from the state to the effect that he says he prefers to go through his examination and to write and finalize his examination before he comes and testify. But there's a different dimension again, my lord, in this instance. In as much as I hear the court is a compassionate court, there's nothing wrong with it. But that should also be understood, madam, around the background with that Mr. Kinenda is doing part-time studies. He knew when he got himself involved in studying that he's a policeman. May I finish, madam? I'll give the court time to ask questions and then I'll have to respond. Because if I start to talk and then the court start to say no, I'm getting disturbed and discouraged. I don't know whether what I'm saying makes sense or not. Because if it doesn't make sense, I don't want to waste the court's time. But basically what I'm saying, my lord, is Mr. Kilenda knew what he was getting himself to when he decided to go and apply for studies. He knew that he's in a public service. He's a policeman. He knew that there will be instances where he will have to go and write his examination. And the protocol in a public service, a person that is writing examination, my lord, is only is given a day or two to go and prepare his studies. On the understanding that throughout the year, he has been preparing for his studies. It is for the first time that I will hear that a person is given almost a month to go write his studies through, to go and write his examination and be absent from work. Basically what is happening with Mr. Kilenda is requesting that he should be absent from work. I'm not so sure whether there's an application for a leave of absence that has been lodged with his employer, which is South African Police Services, or he only has got to be absent from court here for purposes of this evidence. I'm not so sure that if that is the case. But nonetheless, it is not only about Mr. Kiminda, it's also about us as well. The court will also understand that we are running private practices. We have been requested on a number of occasions to postpone our cases that we've been involved or that we are involved in other cases. We have been requested on a number of occasions that we should no longer take other cases that are going to have an effect in this matter. And we have done that. Now, if we are told that we have got to wait, and I've done that. There are cases that I was supposed to be receiving, and I've told attorneys that I am still using that case, I'm unable to assist. Can you please put those cases in abeyance? But now, if I'm going to be told that this court is going to be compassionate, and I'm not saying that the court should be compassionate with Mr. Kiminda's request, but if compassion is what it's supposed to be, then the court should also understand that that compassion as well should be extended to us as well as we are running our private practices. It is very sad, my lord, that when we requested to shed all the work that we should be attending to and concentrate on this case, but then there's a soul who is given almost a month to go and attend to their own issues. I'm not saying that is wrong, but what I'm saying, my lord, is in that vein, there won't be anything that is going to stop me from actually requesting those attorneys to bring back those cases and then I start to attend to them. And when time for me comes for Mr. Kiminda to come and then I come and tell the court that I'm unable to attend because I'm finishing these cases. And I'm not trying to hold this court at ransom.
Yeah, okay, fine, no problem.
Excuse me, madam.
I say no problem. You're not holding me to ransom.
Yes.
Are you through, sir?
I'm not done.
Okay, fine.
Yes. There's also a question of a timetable. We haven't seen this timetable. Mr. Maloyi was suggesting that we should come and see the court in privacy, but we also need to, it's just a paper that has been floated around here. We don't know whether the information that is contained in that paper is a true reflection of what is happening in that timetable.
Okay.
Excuse me. Excuse me. There's also, it's a whole of a dynamic thing. It's not only about the word of mouth that comes from the state and requesting on behalf of Mr. Kiminda that he should be excused from attending this court for almost a month. Another thing, it is also in the interest of this accused person. They are heading to a speedy trial. Once we started, there was no reason for the state at the beginning to have dared to read the testimony of Mr. Kiminda. At some point, this case had to be postponed for almost 2 to 3 weeks with no witness that was available. Then the question that begs this court is why at that time could Mr. Kiminda not have been called to come and testify? Then the state comes and tells this court that no, they would have wanted him to come and testify because he would have come here to summarize everything. What is that, mother? Because basically, there is nothing new that Mr. Kiminda would have said then that would be a different thing that is going to say the time when he comes to testify. There's basically nothing wrong. Nothing new.
Okay.
It is therefore very sad, very sad indeed, that we have to wait for another 2 to 3 weeks, almost a month. It's actually over a month that Mr. Kiminda should come and testify. Because when he comes back, I'm told that he's writing allegedly, because I haven't seen the official timetable. Allegedly, his last day of his examination was on the 26th of November. That is 15 November. 15 November is almost towards the end of the fourth quarter. Okay, that is 25 November, yes.
All right.
That is basically the end of the fourth quarter. We might as well postpone this case to
next year.
To next year. And if that is going to be the case, my lord, I'm going to request compassionately so that I be allowed to continue with the work that I've taken back to the attorneys up until such time that I am also ready to come back to court, and most probably that's going to be at the second quarter of the year. Thank you.
Any person wants to add anything?
As the court pleases, my lord, let me begin by saying, yesterday during the adjournment that we were accorded, Advocate Baloyi took out his phone and indeed put Mr. Gininda on the speaker so that myself, Mr. Mgomezulu, Advocate Ngumalo, Advocate Mushololo could be privy to that conversation. And at heart of what he said, my lord, he said he's also compassionate for this case. He wants to put this case first, the accused persons first, on the proviso that prior to a day of his writing, he's given that day. And we agreed, and that's in accordance with the itinerary of our schedule that we were given previously. So that's an adherence to that.
So you had an agreement?
Yes, that was the agreement. So for him to say today, now preference is for him to finish on the 15th or 25th of November. Sets us back, my lord, in so many respects.
Fine.
As the court pleases,
Yes, Mr. Nomalo.
My lord, I confirm what has been said by my colleague. Yes, thank you.
My lord, I am the one, my lord, who spoke to Brigadier Gininda over phone yesterday, and we agreed that he was going to avail himself on the days when he is not writing examinations, and then he will only ask to be excused a day before the date of the examinations. So we'll be given dates in pairs of the examinations. And then I asked him for the timetable. He said he has given it to Advocate Baloyi. I said, we haven't seen it. We're not even sure whether we'll be writing those exams. I asked him also if the study leave for such dates have been approved by the employer. He said he will also send that information to us. My lord, my submission is that it will be unfair, my lord, to excuse this witness for the entire duration of 14 October to 25 November. Because that will mean that the witness will be excused even on the days when he will not be sitting writing down the examinations. And that will be contrary to the study leave that has been approved by the SAPS, because he has not been granted leave from 14 October to 25 November. And therefore, he is not entitled not to come and testify in this court when he is not on leave. He is only entitled to not to be in court on the dates when he is on study leave. Those are my submissions, my lord, that this will also cause a delay in the finalization of this case. Also, my lord, I would also like to add and put to the attention of the court that we have been informed of our judge president's intention that he intends this matter not to be delayed. We have been instructed as defense counsels to take away our work. I have an order of course against me when I was not in the court where I should be, and I had to attend this court and the order was granted against me. My lord, therefore it is my submission that it should not be whether Gininda feels he will be able to attend or not. It should be the order of the court that Gininda comes and testifies on the days when he is not on study leave. That's my submission, my lord. That will be the fairness that will be done in this court. Above that, my lord, Gininda is the investigating officer in this case. He knew long time ago that he was going to come and testify. He knew that his examinations were set down for November. He ought to have indicated to the state and requested to come and testify before the term of his examination comes. He decided to stay and let other witnesses testify. We have started this case from the beginning of this year. He should have come and testified, my lord. in order for him to be excused during the period of his examination. And therefore, my lord, I object even before he placed the application before this court that he be excused on the days when he is not writing or on the days when he is not sitting down for his examination.
So he mustn't be excused even on the day he's not right.
No.
He's writing.
My lord, he must be excused only on the days when he is writing and also a day before or when he is writing examination.
Yes, sir.
Those are my submissions, my lord.
I confirm the
You
same
confirm the arrangement.
arrangement with my colleagues.
Can I just respond, my lord, if I can? I don't know if I mentioned this, but let me mention it now, my lord, that in light of the fact that this witness who is due to testify was traced, Brigadier Geninda then felt that we can then carry on with this witness. He's basically not available for the whole of next week in terms of his exam timetable, except the 17th and the 18th. So depending on how long this witness will take, the witness might take us into sometimes next week, in which case, my lord, that will then overlap with his exam study. But I did mention that he was then going to, in addition to the days that is giving us, to check which ones require more time, the portfolios. And my suggestion is, my lord, that we have to now determine as to whether the state will be allowed to lead this evidence, and depending on the outcome, we can then take it from there. I mean, if, for argument's sake, if the state is allowed to proceed with the witness, that should occupy us for some few days to come, my lord.
Okay. I wasn't aware that there was an agreement which was actually entered into between the state, the defense, and Brigadier Geninda. There was an agreement, in other words.
Well, as I mentioned, that was before this witness
Yeah,
was
fine,
traced.
fine,
Yes,
but there was an agreement.
Yes, that I confirm.
Then it absolves my compassion, because there was an agreement. So Mr. Geninda, Brigadier Geninda should come and testify, as agreed amongst yourselves. Is that okay?
As a court please. But that will then depend on the
Depends on
outcome.
nothing.
On the outcome of the.
You can't say
Yes.
depends.
Yes.
Because if you were to talk about it depends on
Yes.
this witness being written by a bulldog.
No. What I'm saying is,
I hear you.
depending on the outcome
I
of
hear you.
the judgment,
Yeah.
Geninda will then testify after this witness.
Yeah.
Yes, that's what I mean.
Okay. The court will then adjourn. We don't have to come back at 2.
As the court pleases.
The client wants to see you there.
May I approach?
Should we adjourn or wait for your client?
Can you wait for a few minutes? Thank you, my lord, for indulgence. My lord, the instruction is about the ID of accused number 1, the identity document of accused number 1.
I thought you guys were handling it.
The ID document is here with Sergeant Mukhola, and there
Where's
was
Sergeant Mohol? She's not here today.
she was here with us. We saw even the identity document.
Yeah, so
Then we had a discussion with my colleague, Mr. Valoy, Advocate Valoy, to the fact that if the state is inclined to hand up, let it be through the order of the court and place certain conditions.
haven't you agreed that you are going to...
That is not the agreement.
Yeah,
The
that's
agreement
not-
is that we have a certified copy of the identity document.
Yeah.
We show them the original and a certified copy and said for the purpose of applying for NSFAS by accused number one's children, they just need a certified copy, which we have offered to them, but they are refusing to take that certified copy. They want the original. And we said there's nowhere where they insist on a person's original document where the person himself is not there. A certified copy is always sufficient, which we can give to them now. Actually, there are 2 certified copies, my lord.
It's not only about NSFAS. If the family wants to use the ID, they visit the accused at Modapi, they want the original document wherever they want to use it. So we can't keep on making certified copies. If the original is here and the state has no reason to keep it, because it has been made clear that they want to hand it over based on the conditions that he must not dispose of that identity until this matter is finalized. That's the impression I got from Advocate Baloyi. Yes. And the investigations are complete. The matter is in the middle of a trial.
Where is
Yeah, my lord, without belaboring the point, and we're sorry to burden the court with this matter, I thought we have reached an agreement. We indicated to them that we are offering them a certified copy, and we will have further discussions with the investigating team to see if it is safe to give the ID document back to accused number 1. And depending on whether it is safe to do so, if it is safe, then it will be a formal process where the state will put on record that the exhibit is being handed back to the accused, and the request that the accused should keep it until the finalization of the case. That is normal. That is the normal position. So what should happen now is they should. We've offered them the certified copy, and pending the outcome of those discussions, they have the certified copy, my lord.
Okay, so you let me know tomorrow then.
Yeah, that's the court, please.
Okay, the court will adjourn then.